Tonight's case is a powder keg, State of Wisconsin versus Kelly Nelson, probation on a Class E felony for meth possession with intent, and now the court's back to decide if conditional jail gets added after a string of alleged violations. You'll hear a DOC agent outline missed check-ins, a pulled-over traffic stop with kids in the car, and refused drug screens over the July 2nd to 4th weekend. Nelson says it's all explainable, bad timing, miscommunication, and grief after a miscarriage, but the judge isn't buying generalized excuses. Watch for the moment the court says it can order anywhere from 0 to a full year. Question for you, based on what you're about to hear, would you treat these as slip-ups or a pattern?
State of Wisconsin versus Kelly Nelson. Appearances are, we do have the state appearing through District Attorney Kevin Schmidt in person. We have Kelly Nelson appearing by video conferencing in custody in Burnett County Jail. We have Alexis Bebo, Department of Corrections agent. We're set here today in this matter due to a request and a petition.
Quick legal framing: a probationer on a Class E felony, meth, 3 to 10 grams, was given a generous break, probation instead of prison. That deal comes with strings: report where you actually live, follow supervision rules, avoid criminal contact, and submit to drug testing when directed. Importantly, today isn't a new trial, it's a probation review to amend the judgment with conditional jail if violations are proven. Standards are lower than beyond a reasonable doubt, and judges have wide discretion. The state's here through DA Kevin Schmidt. DOC agent Alexis Bebo provides the supervision record. Nelson appears by video from jail. The judge calls this a very sweet plea. Translation: the leash is short, the hammer is heavy, and credibility will matter a lot.
To amend the judgment of conviction and add some conditional jail time due to some violations that are alleged to have occurred by Ms. Nelson. This is a very serious case. The court recalls the facts very clearly as it relates to this matter. And Ms. Nelson was given a very sweet plea deal with the state to plead to possession with intent methamphetamine, over 3 grams but less than 10, a Class E felony, and she did receive probation instead of a prison sentence at that time. So Ms. Bebo, we're here due to the department's request for conditional jail and Ms. Nelson's, I think, objection to that?
Yes, she is objecting to the conditional jail time.
All right. So Ms. Bebo, can you please provide the information and recommendation to me, please, to the court?
Yes. So I did not write down this date, but conditional jail time was ordered months prior to her being placed into custody July 2nd of this year. Due to some methamphetamine use, possession, she refused to provide UAs while in custody during that time and refused to go to court. Then she was released from custody, Then she turned herself in to the Barron County Jail to go to court, essentially. She was then released. She did not have an active phone number. When I attempted to contact her mother, who was the person that she was intended to live with, who she's reported that she lives with, to us, I contacted her mother. She said, I don't know, she's probably at her apartment. At that time, I was under the understanding that she was no longer living in Cumberland, Wisconsin, and that she was back in Turtle Lake. So I issued a warrant for her arrest, and she was pulled over by Cumberland Police Department.
Yep.
Okay. She was pulled over by Cumberland Police Department. They did give me a call. She had her children in the vehicle with her and requested how they should move forward. I did let them know that she should be taken.
Here's the sequence. A warrant issues. Cumberland PD stops Nelson with her children in the car. They call the agent. Nothing illegal is found in the vehicle. She's taken into custody to address violations. Legally, the absence of contraband doesn't erase supervision issues. DOC can still act on failed reporting, address misstatements, or suspected drug use. Then a big policy point. The agent says Nelson encouraged another probationer, Joseph Carter, to violate, and that there was a DOC no-contact directive. That's not a protective order from a court, it's a supervision rule, but it still counts. Nelson argues she believed contact was allowed if both were compliant. For you at home, is that
Taken
a
into
reasonable
custody so we can deal with these
or an
violations.
after-the-fact justification?
Her vehicle was searched, nothing was found. She was placed into custody. I got a statement the same day, or possibly no, it was the same day. I got a statement from her in regards to the violations of encouraging another client to violate probation. She was very well aware that Joseph Carter was on probation and had a no contact with her. And this had occurred months prior. And
That was a no contact provided by DOC.
yes, yes.
So she hasn't violated the no contact with Mr. Nelson or Ryan Wren?
Not, no.
Okay.
And then I had just asked her questions about where she was, what her plan was, why she's not in Polk County. Her response has been that she does not want to transfer offices. So this is her reasoning for reporting an incorrect address and giving us her mother's address. And while I empathize with that, it is a requirement that you are supervised in the county, that you do reside.
I don't empathize. I have not been able to speak today with that.
Me either.
Because that's the law.
Exactly.
And
Yep.
that's the rules. And if she likes you as her agent, that's great. Maybe
This passage is crucial. DOC requires you to be supervised in the county where you actually live. Nelson says she preferred not to transfer offices, so she reported her mother's address. The judge calls that out plainly. Rules are rules. Then the UA refusals, July 2nd, 3rd, and 4th, multiple attempts, no sample provided. In supervision settings, refusing or failing to provide often carries the same inference as a positive test, especially when timing surrounds alleged use. Also note the judge's advisory. In this hearing, silence can be used against Nelson, and the court isn't bound by DOC's 51-day recommendation. It could be 0, or up to a year. Engagement check. Do you see these as procedural missteps, or clear red flags?
wonderful agent that's able to move with or hold them accountable and be nice and work well, but that's the rules. The rules are the rules.
Yes.
Okay, so continue. Or is that all?
And then as far as not contacting me, she stated that she does not have funds for a cell phone or for gas, food, etc. So basic needs, and that is why she did not report to my office. And she did state that she didn't have reporting instructions, which, as far as I am aware, a Burnett County siren agent out of the siren office did give her a report date of when she should be seeing me, and she did not show up. Following her being placed into custody, I sent a request to obtain a UA. It appears that on July 2nd, 3rd, and 4th, she failed to provide a UA to jail staff. And then I followed up after the holiday weekend, and they had stated that after multiple attempts, she still did not provide a UA. And after the 4th, it was not requested again. So at this time, I do not know if she was under the influence of any illegal or illicit substance since being released from the Barron County Jail until up to the time that she was placed into custody.
All right, thank you. Ms. Nelson, I'm now going to ask if there's anything that you would like to say to me or you would like to let me know as it relates to this matter. I believe, are you still just asking for, I believe it's 51 days?
Yes, ma'am.
51 days of conditional jail is being requested. You requested to have a hearing, so I just need to make you aware that, and I'm sure Ms. Bebo made you aware that on a probation review hearing such as this, in which conditional jail is being requested and the court is being asked to modify the judgment of conviction, the court has no obligation or duty to follow the recommendation of the Department of Corrections, meaning that I do not have to order 51 days conditional jail. I could order 0 if I find that it's appropriate. I could order up to a year if I find that that's more appropriate. You have the ability and right to say what you wish to tell me. This is not like any other criminal court hearing you've had, because I can use your silence against you. So please let me know what you would like me to consider and what you are asking of the court.
Regarding the contact with Joseph, I was informed by his PO that we are able to have contact as long as we're both doing what we're supposed to be doing. And she was fine with us writing for having contact while he was in jail. Along with the Turtle Lake address, I went to my Cumberland apartment to pack it up so I could move out of it. And when I got out of jail, I didn't have the funds and things didn't go as planned, but I did not receive an appointment from Burnett County, the guards here the agent. She did not tell me a report date when I got out, so I didn't miss appointment on purpose. And when I got pulled over, I was gonna drop my kids off and come to probation, actually. That was my plan. But I got pulled over first. Yeah.
All right, so anything else?
No, I don't believe so.
So go ahead.
The rest of all of the stipulations you gave me for completing paper, I've got through all of them and I'm in the process and will have my GED or HSCD within the next 3 weeks here at the jail. They have a program. So I'll have that complete as well. And yeah, I've done all the parenting classes.
This is the case's emotional and credibility hinge. Nelson describes a miscarriage, depression, efforts toward GED/HSED, parenting classes, and plans for immediate employment. Those are mitigating facts, real-life context judges consider. But mitigation doesn't erase non-compliance. The court drills down: if you avoided testing, why? If you were headed to probation, why were there contradictory signals and no verification? The agent clarifies the July dates and who requested UAs, jail staff. For the audience, judges often weigh effort versus honesty. Showing progress, classes, job plans, helps, but truthful, timely compliance is non-negotiable on probation. Question: after hearing both sides, whose timeline and details feel more consistent to you, the agent's paper trail or Nelson's explanations?
And everything else, I just have to finish my HSCD and pay my $500 and some, I think it is. And
So you had gainful employment?
I did in March, or before I went to jail then. And when I get out, I'm planning on going to the Butterfly House now, which therefore I will have immediate gainful employment. And yeah.
The other condition, another condition was no use or possession of alcohol, illegal drugs, paraphernalia, any controlled substance without a valid prescription. Are you telling the court you didn't violate that? I didn't. 2.5 years, that was good. I had a miscarriage and it slipped up, but it was a minor slip up and I was already getting sober again when it all came to service. And
I've regretted it ever since. And
Is that why you avoided your agent in February?
No.
Why did you avoid your agent for those 3 days?
Oh, well, I was in jail. I just had a miscarriage. I was depressed and.
No. Was it February 2nd, 3rd, and 4th?
That was July. So I believe what
Sorry.
she's referring to is the last conditional jail time that was ordered
Yeah.
previously.
All right, but with this July 2nd, 3rd, and 4th, when you were being asked to go meet with your agent, why were you avoiding that?
Judge Morgan, I apologize. That was the corrections officers at the Barron County Jail who were requesting or directing her to provide UAs, and she was refusing.
All right,
Yes.
thank you. Okay. And she just said she was unable.
I did not get a response as far as what she had said, was just that she would not provide one after being asked multiple times.
Okay, why didn't you provide a sample for the corrections officer when you were in custody?
The first time was right before I gave my statement, and I still hadn't received a glass for water. I was there for 2 hours, and they were busy. And the second time, I don't know.
How about the third time?
I don't even remember being asked a second or third time, honestly.
All right. So if I am to believe the statements that you're telling me here today, are you telling me that Miss Bebo and her connections and the information provided to her are wrong and are lies?
I'm not saying she's lying, but it's not, I don't know. The address thing is not what, I don't know.
You never told her that you didn't update or give your correct address of where you're living, which is a requirement.
Yeah, and she knew
because you didn't want to move or transfer agents?
She knew about the apartment address, and I told her I was moving back in with my mom, which I was moving back in with my mom. I just had to go pack up my apartment. That was.
Ms. Bebo, were you under that impression? Did you know that she was just going to that apartment to pack it up?
No, Judge. I was not aware that she was living in Cumberland until she was arrested and served conditional jail time the first time. And then I was again under the impression that she was being evicted and would be living with her mom upon release.
Yeah, that was.
Is that accurate, Ms. Nelson?
Yeah, that was my plan, was moving back in with mom.
Now, what I'm asking, if it was your plan, because your plan was wrong and it was violating DOC policy, state law, and the court's conditions of your judgment of conviction. So all I'm hearing from you, all I've heard from you, Ms. Nelson, are excuses, why I didn't do what I was told to do, why I didn't do what I was legally supposed to do, why I didn't do what Department of Corrections requires me to do. Because I've heard excuses and the opposite of what Ms. Bebo has stated here in court. And so you're essentially telling me that Ms. Bebo is lying.
That's not okay.
And it's hard for me to believe that the day that you were pulled over with your kids in your car, you were driving to drop them off so that you can go see probation. It's always that. I'm going to tell you, this isn't the first time I've heard this. People are always on their way to Department of Corrections to turn themselves in. They're always having an interview the next day when they're in custody or the day of they got picked up. They're always starting a new job, and so they need to be released from custody. They're always doing what the court told them to do, but for the fact that they got picked up and they got arrested. All I heard were reasons, again, that were completely opposite than the information and facts that I was provided by Ms. Bebo. I need to state that you were given a very very sweet plea deal, but for the fact that your attorney argued for your rehabilitation, you faced a very serious prison sentence. It's a Class E felony, a Class E felony. That means you could face 15 years of incarceration, 10 years of initial confinement, and then the 5 years of extended supervision.
Mhm.
That's hanging over your head right now.
I understand.
That should be a huge hammer hanging over your head, where you say, Ms. Bebo, I'm going to do everything that I need to do. I need to follow the law. I need to follow the judge's orders. I need to follow what the Department of Corrections is requiring of me.
Mhm.
You were also provided the ability to reunite with your children, because during that time, I can't recall if it was Barron County,
Polk.
removed your children from your care. I understand relapse, and I understand it very completely with doing the treatment court. That happens.
Mhm.
But there are ways that you work, in the ways that you use the tools that you've learned after a relapse. And that includes having the people that are there to help and assist you and guide you, and having those conversations. Ms. Bebo is one.
I
Going
was,
to A is another. Based upon the information that I have here today, I do find that you have violated numerous conditions of the court on the judgment of conditions, as well as violated your rules and policies of the Department of Corrections. I'm ordering conditional jail. I'm ordering 120 days, not 51, 120 days. You have 15 years of incarceration over your head. That means no little white lies if you believe they are lies. Here they weren't.
Here comes the gavel moment. The judge finds multiple violations of court conditions and DOC rules, and ups the conditional jail to 120 days, more than double DOC's 51-day ask. The court also orders cognitive behavioral programming, MRT, or thinking for a change, aimed at confronting so-called criminal thinking patterns, distortions like minimization, excuse-making, and rule-bending. Critical takeaway: when a judge says a Class E felony carries up to 15 years, 10 in, 5 on supervision, hanging over your head, that's a warning shot. Conditional jail is the intermediate step short of revocation. Viewer poll: was 120 days the right call to reset compliance, or would you have stuck with DOC's 51-day recommendation?
Little white lies. I don't believe that for a second. You blatantly lied to Ms. Bebo and to others of authority to do what you want, how you wanted to do it, thinking you could get away with that. That's called criminal thinking. That's criminal thinking. Has she been engaged in any MRT or other such programs?
She was not enrolled in any program when she got transferred to my case, no.
All right, well, I'm also going to order that. She has to do either a thinking for a change or breaking barriers, MRT, something of that nature.
Polk County just started MRT.
Okay, excellent. You are still using that criminal thinking brain. I understand the loss, a miscarriage, but a loss of a child. I completely understand that. I understand having the sorrow and the pain. I also understand reaching out to others who can keep you on that sober path and keep you on the non-criminal path. Because Ms. Nelson, it may come down to it where the department's going to next ask that you be revoked and you be sentenced with 10 years of initial confinement and 5 years of extended supervision hanging over your head. That is nothing that you should take lightly. So 120 days from date of arrest or pickup. And it appears that I'm going to have more probation review hearings with Ms. Nelson because she's not understanding the risk. And if not only does the Department of Corrections, but if she needs the court to babysit her to make sure that she understands that risk, I will. I can do October 6th at 2. Zoom is approved for the agent. If she is out of custody, if you are out of custody, you must be here in person. If you are not out of custody, I think you should be, but you can be by Zoom as well. Anything further, Ms. Vivo?
No, ma'am, thank you.
All right, thank you. We are adjourned.
Final breakdown. In 21 CF 245, the court reviewed supervision performance after a lenient probation sentence on a meth Class E felony. Key friction points were address accuracy, county of residence supervision, contact with another probationer, and refused UAs across July 2nd to 4th. Despite Nelson's mitigation, education progress, parenting classes, planned employment, the judge found a pattern of non-compliance and imposed 120 days of conditional jail plus cognitive programming. A follow-up probation review is set for October 6th at 2 o'clock, with Zoom allowed for the agent. Your turn. Was this accountability or overreach? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.